Straight ahead on Law and Crime Daily, the death of Ahmaud Arbery trial.
There was no report made by Mr. English of a burglary at his residence.
Why this witness testimony could be a game changer for the prosecution. And the conservatorship of Britney Spears could soon be over. What that ruling would mean for the famed pop star. Plus, a victory for former President Donald Trump as an appeals court temporarily blocks the release of his January 6th records. And later, the contentious case of Kyle Rittenhouse.
Do you think what you're doing is the best thing under all the circumstances?
Yes.
Has anybody threatened you or pressured you or forced you in any way?
No.
We go inside the courtroom for the last time before next week's closing arguments. Law and Crime Daily, covering court cases from coast to coast. Welcome everyone to Law and Crime Daily. I'm Imran Ansari, filling in for Brian Buckmeyer. Along with me in New York is co-host Terry Austin. We begin with the death of Ahmaud Arbery trial in Georgia. Defense attorney Kevin Goff offers his apologies after saying, quote, "We don't want any more black pastors coming in here," when Reverend Al Sharpton made an appearance in the courtroom.
If my statements yesterday were overly broad, I will follow up with a more specific motion on Monday, putting those concerns in the proper context. And my apologies to anyone who might have inadvertently been offended.
Goff represents William Roddy Bryan, a defendant in the case alongside father and son Gregory and Travis McMichael. All three face several charges in the death of Ahmaud Arbery, including malice murder, felony murder, and aggravated assault. In February of 2020, Gregory and Travis McMichael tailed Arbery in their pickup truck as he went for a jog. Travis McMichael eventually shot Arbery, and now he's claiming self-defense. Bryan followed along in his own pickup truck and recorded the incident in a now famous viral video. At the time of the shooting, Arbery was unarmed and jogging near his Brunswick, Georgia home. All three defendants face life in prison if convicted. Our own Brian Buckmeyer is covering the trial live in Georgia. Brian, Friday saw some intense developments that came out of cross-examination. What happened?
Absolutely, Imran. During the testimony of Officer Rash, Prosecutor Dunikowski and defense attorney Franklin Hogue went back and forth about whether or not this officer could define burglary. But just before objecting, Dunikowski let the witness explain.
At that point in time, there not have been a crime reported. There was no report made by Mr. English of a burglary at his residence. I was not on duty the day that he called. Had Mr. English called the police department and made a formal report, if weeks later I would have had come in contact with Mr. Arbery and identified him, then I would notify whichever officer took that report and say, I have identified this male, here is his name. That officer himself, or it may have been handed off to our CID, Criminal Investigation Division. One of them would have followed up and looked into that. Myself, that was not being I was not the officer who took that report, I would not be the one following up doing that investigation.
Sure, and I'm not suggesting you would have been the one to go out and investigate the burglary, but some investigator would have in the normal course of things. Right.
An officer or an investigator.
Officer Rass's explanation seemed to suggest that if there was a burglary complaint, which there wasn't, that an officer would have to identify Arbery, then investigate the case for there to be a burglary investigation or arrest, suggesting that the officers didn't have probable cause based on what the officers knew prior to February 23rd. Thus, neither were the McMichaels. And with no probable cause, there's no citizen's arrest. Then the court broke for lunch. During the lunch break, Jason Sheffield, attorney for Travis McMichael, came out and said that Kevin Goff's comments that they do not want any more black pastors was, quote, asinine and not endorsed at the time in which it was said. He quoted saying that he merely just sat there and was surprised that it was heard, or that it was endorsed afterwards, as he alone came out and spoke that the other defense attorneys did not agree. Court continued after Officer Rash's testimony with Officer Seacrest's testimony, where video of the officer and William Bryan was played while Bryan described the chase.
Now, Brian, I'm still shocked at the statement. What kind of aftermath did we see after Kevin Goff called for no more black pastors in the courtroom?
So it was interesting. We saw not only in the court, but in just the community generally, first, Benjamin Crump as well as Lee Merritt made social media posts with Ben Crump saying he was going to come here with 100 black pastors sometime next week. We're going to still wait and see if that occurs. I got to speak with a number of sheriffs who are concerned that they may have more people coming down here where for up to this point it's been pretty peaceful and well run by both activists and family members.
Yeah, and Brian, Kevin Goff threw out the term carjacking in his cross-examination. How did that play out in court?
So he brought up that term when questioning Officer Seacrest. That's the individual officer who questioned William Bryan when he was just merely a witness. And this is in relation to that handprint on the door or driver's side, of the truck. And we've heard that William Bryan's defense attorney, Kevin Goff, has tried to describe this as Mr. Arbery trying to get into the vehicle. But this was the first time that he used that inflammatory term of carjacking, which was objected to and I believe sustained. But even the officer who was on the stand shut him down and said that he would not describe this as a carjacking, considering that Ahmaud Arbery was being chased, as the prosecution is saying, for over 5 minutes, that an individual who is trying to evade being angled or cornered or pushed off the road into a ditch, as William Bryan described, would not be attempting to carjack, as the defense attorney Kevin Goff was trying to argue.
Yeah, Brian, Kevin Goff not choosing his words wisely. Brian, thank you for your great reporting as always. And now on to news out of South Carolina, where a settlement is reached in the lawsuit involving disgraced lawyer Alec Murdoch and his former housekeeper's family. All this as Murdoch is denied bond for a second time. This week, a judge ruled Murdoch could not be released on bond, saying a psych evaluation confirms he is a danger to himself and the community. Murdoch faces 2 sets of charges. The first stemmed from a misappropriated settlement fund in the death of his family housekeeper, Gloria Satterfield. Satterfield died mysteriously on the Murdoch family property in 2018. An autopsy was never performed. Her children claim they never received any settlement money, but this week reached an agreement with the involved bank. Murdoch also faces charges for a botched suicide for hire scheme, so that his surviving son could receive a $10 million payout from a life insurance policy. All this comes months after his wife and son were murdered on family property. Murdoch has since been named as a person of interest in that case. And on this week's episode of Law&Crime's Network's Coptails and Cocktails podcast, Sergeant Sean Sticks Larkin hears from former Los Angeles County Sheriff's Department Detective Fred Reynolds.
We had a case, we find a suitcase on the sidewalk. It's like 7 o'clock in the morning, and some lady on her way to work, she sees this suitcase on the sidewalk, and it has blood coming from the side of it. So she calls the patrol unit out. Patrol unit get there, and it's kind of like, hey, this doesn't look right. So we need to call detectives. We get out there, man, and there is a woman. Her name is Carmen Villegas, never forget her name. There is a woman stuffed inside that suitcase, naked. And the autopsy later revealed that she had been stabbed like 81 times. Damn. So somebody raped this poor woman, stabbed her 81 times, put her in a suitcase, and dumped her on a sidewalk in Compton.
This week's episode is available now on Apple Podcasts or wherever you listen to podcasts. And still ahead on Law and Crime Daily, former President Trump's White House records still under wraps, at least for now, when we could see the January 6th documents from the former commander-in-chief. But first, Britney Spears may soon be freed of her 13-year-long conservatorship. What's ahead for the famed pop star after this?
It was the video that shocked the nation. An unarmed black jogger, 25-year-old Ahmaud Arbery, gunned down in broad daylight. The 3 men charged will now stand trial. For live gavel-to-gavel coverage of the trial, subscribe to Law and Crime on YouTubeTV today.
Welcome back to Law and Crime Daily, and after 13 years, the conservatorship of pop star Britney Spears may soon come to an end. In a hearing set for Friday, a Los Angeles judge is expected to terminate at least one part of the arrangement, including control of Spears' finances, daily activities, social life, and medical treatment. The 39-year-old was under her father, Jamie Spears' oversight beginning after her public breakdown in 2008. Jamie Spears remained her appointed guardian until September of 2021, when he was suspended from the conservatorship. Spears' case is especially unique in that she has continued to perform and work extensively as a global celebrity amidst the conservatorship that deemed her unable to care for her own finances. If the conservatorship is suspended, Spears' legal battle will continue, as her attorneys filed a petition to depose her father related to allegations he illegally placed recording devices in her bedroom. So let's bring in my co-host Terry Austin and Law&Crime legal analyst Dina Dahl to break this down. Terry, I'm going to start with you. This case has put a focus on conservatorships in the United States. How do you think this will make a change in the way conservatorships are handled in the future?
It's already making some substantial changes across the country. To get a conservatorship, you have to have a court order, and it's usually by a relative or a third party. And it happens when someone is lacking the mental ability to make decisions either over their person or over their finances. And there are about 1.3 million across the country. But this case has really highlighted what's going on. Some of the changes include making it easier to end the conservatorship. So if someone makes that request, they don't have so much to prove. The other thing is limiting the conservatorship so it's not over everything, just over that limited aspect that the individual has difficulty controlling.
Yeah, and Dina, Spears' attorney argued that she has been of sound mind for some time, but remained under the conservatorship for more than a decade. Is there any possibility for retribution should Spears be freed of the conservatorship?
It's possible. I mean, her attorney has basically already said that they are going to be looking into the finances of whether or not her father had any mismanagement. So certainly they will pursue that if Ms. Spears decides to, as well as you mentioned, this illegal recording. You know, in the state of California, it is illegal to record a conversation without the other person's consent. Whether or not the security firm is implicated in that, Mr. Spears himself, that may also unfold into some liability.
Right. Great analysis, you two. And now we're moving on to international legal news. Olympic runner and convicted murderer Oscar Pistorius is up for parole after serving nearly 8 years in prison in South Africa. Back in 2013, Pistorius was sentenced to 15 years in prison for the murder of his girlfriend. Pistorius admitted he shot Reva Steenkamp 4 times, but claimed he mistook her for an intruder. Pistorius has served half of his sentence, which automatically qualifies him for parole under South African law. Before parole is granted, Pistorius will undergo psychological evaluations, social worker meetings, and a mediated conversation with Steenkamp's parents. Ahead of the deadly shooting, Pistorius made headlines as the first Olympic sprinter who was also a double amputee. Pistorius had both legs amputated below the knee as a child. And coming up on Law&Crime Daily, the divisive case of accused murderer Kyle Rittenhouse is nearing verdict watch. Plus, a victory for former President Donald Trump, if only for a few weeks. What a federal appeals court ruled regarding his January 6 records. All that and more after the break. Welcome back. A federal appeals court grants former President Trump a temporary victory, blocking his White House records from the so-called January 6th committee. On Thursday, the court granted a last-minute administrative injunction, meaning Trump won't have to release any documents just yet. This ruling pushed up against an original Friday deadline when the National Archives were set to release Trump's White House records to the committee. All this stems from the January 6 riots and attacks on the U.S. Capitol. Former President Trump argues executive privilege over the emails, memos, and conversation records leading up to the riots. He also says witnesses subpoenaed by the committee should not have to answer questions. Most notably, former Trump advisor Steve Bannon refused to comply with a subpoena and now is the subject of a criminal referral to the Justice Department. President Biden shot down Trump's claim of executive privilege, saying the National Archives should release the records. On Thursday, the appeals court asked lawyers for Trump, Congress, and the Biden administration to submit briefs ahead of oral arguments now set for November 30th. Dina and Terry, let's break this down. Dina, I'm going to start with you. Former President Trump is working overtime to keep these records a secret. What information could possibly be in those records, and how could they possibly incriminate Donald Trump?
The documents that are under this executive privilege claim include presidential diaries, activity logs, call logs, visitor logs, and draft speeches. So all of those could be helpful to the committee to determine who President Trump was talking to around January 6th, what kind of phone calls he did or did not make that day in the middle of the attack on the Capitol, and also these draft speeches. What was the language like, in the drafts before the speech he did ultimately give that day?
Yeah, and Terry, President Biden has stated that former President Trump cannot assert executive privilege and that Trump must turn over these records. Could that hurt Biden in the future?
It could hurt Biden, but I think that is the proper argument. I think that this privilege is an executive privilege, and it only applies to the incumbent because he is the executive at that time. But eventually, Biden will be out of office, and it could very well be one day people are calling for his diaries and his calendars, and he would lose the argument at that point, if in fact it prevails.
Yeah, it's a temporary injunction, and we will see how it plays out in court. And when we come back, the contentious case of accused Kenosha shooter Kyle Rittenhouse is nearing verdict watch. Hear from the case's judge, who explains the potential outcomes Rittenhouse could face. Welcome back to Law&Crime Daily, and both sides rest in the fast-paced trial of Wisconsin versus Kyle Rittenhouse, ahead of Monday's jury instructions. Both sides focused on the charges in the case. 18-year-old Rittenhouse faces charges of reckless murder and attempted murder in connection to the August 25th, 2020 shootings in Kenosha, Wisconsin. Two men, Joseph Rosenbaum and Anthony Huber, died as a result of the shootings. Gage Grosskreutz was shot and wounded but survived. Rittenhouse's team argues the defendant was acting in self-defense that night. The judge ruled the jury could stay home on Friday as the defense and prosecution went head-to-head on Rittenhouse's lesser-included charges. In the end, Judge Schrader explained to Rittenhouse what outcome the jury could find after hearing closing arguments on Monday.
By having a lesser-included offense included, you're raising the risk of conviction, although you're avoiding the possibility that the jury will end up compromising on the more serious crime, and you're also decreasing the risk that you'll end up with a second trial because the jury is unable to agree. If the jury finds that none of the crimes charged in the sequence, charged or submitted, has been proved beyond a reasonable doubt, then they must acquit you, they must find you not guilty. And they cannot convict you of more than one crime on each count.
Okay, so a less dramatic day in court, but an important one nonetheless. Dina, now that the case is drawing to a close, how well do you think Rittenhouse has been able to establish a self-defense argument?
What we all saw in the courtroom there, his testimony, the witnesses the defense put forward was very strong for the defense. But we cannot discount what happened today. As you said, it was less dramatic, but very helpful for the prosecution because they're going to have an instruction regarding provocation. Did he provoke it? What should he have retreated? When you see the facts of this case, that's essentially what happened. He did provoke it and he didn't retreat. And that might be the difference between guilt and innocence. That and the lesser included charges are also very important and could also go a long way to the prosecution pulling off a conviction here, despite the fact that they had a very bad day in court.
Yeah, Dina, I agree. And Terry, the prosecution ran into a lot of trouble with the judge. How well do you think the prosecution did overall?
I think overall, Binger missed some opportunities. There's no question that Judge Schroeder really disliked Binger because they got into that major argument about Rittenhouse's right to silence and the fact that Binger almost crossed that line. And the judge was also angry that he thought that Binger was trying to put in evidence that he had already ruled could not come in on these, prior instances. But overall, I think Binger should have included those lesser included charges because he had to fight today to get the jury instructions worded the way he wanted and to get those lesser included charges. And you heard the judge there explaining to Rittenhouse how that could be pros and cons. Having more charges means he could basically be convicted. Having fewer charges could work against him, but it could work for him. So I definitely think Binger should have started out with those charges, giving the jury an opportunity to consider all of the possibilities against Rittenhouse. So at the end of the day, I guess we'll see what happens.
Yeah, we will all be watching those closing arguments on Monday. Thank you for joining us here at Law and Crime Daily. We will see you next time as we discuss justice in America.